of the things that's wonderful about Margot Kaminski, only one of many, is that she spent the last year in Europe, and so all of the information that she's giving us today about the EU AI Act is going to be really fresh stuff. So thanks so much, Margot, for agreeing to be here. She's a professor at the University of Colorado Law School and head of the privacy group at Silicon Flatiron. So, welcome, Margot.
Thank you so much, Pam. Thank you to everybody for having me. I also, without naming everybody, want to thank the people that I learned from while I was in the EU, at least one of whom is currently in the audience. Michael, hi. This is an absolutely impossible task. It is the last tutorial of the day. The law is 458 pages long. It's 113 articles, 180 recitals, and 13 annexes, and I have to try to keep you awake through that. So I'm going to do the best that I possibly can. My overview today is going to be that I'm going to start with a short primer on relevant EU law. Who here has EU legal background? Okay, that's not nobody. So I'll try to cover that, but cover it relatively briefly. Then I'll give an overview of the AI Act itself, its contours, and its enforcement mechanisms. We heard an earlier question about enforcement and how to make people pay attention. That arguably exists in the Act, but we'll discuss it. And then if I have time, and that's a big if, I'm actually taking my watch out so I can see right now, I will get to some policy observations at the end, and maybe Q&A, but probably just discussion outside afterwards. Okay, so getting started. Oh wow, this doesn't go through animations. Okay, so the EU AI Act, at its core, is delegated risk regulation. What do I mean by that? At its very core, what it does is it tells the developers or providers of AI systems to basically do what NIST is telling people to do in the United States, to map, manage, mitigate risks. And those risks are very specific. They're articulated as risks to health, safety, and fundamental rights. There is relatively little oversight in the Act, unless and until something goes wrong. And as Michael and others have pointed out, it's built on the scaffolding of EU products safety law. This makes it, even though it's got similar risk mitigation measures to the General Data Protection Regulation, if you look at them just sort of facially, it's fundamentally different as a structure, as a regulatory structure with regulatory design, from the human rights-backed instrument of the General Data Protection Regulation. So that's a normative claim. I think a lot of people agree with it. It's not solely coming from me. However, that risk regulation, that delegated risk regulation, is not all that the AI Act contains. It was enacted over time through a complex legislative process. There were back and forths, and therefore it also contains an intertwined regime for what the Act refers to as general purpose AI models. That would be largely mapping onto the concept of generative AI systems. There are also additional ad hoc elements that were added throughout the Act. I'm seeing Michael nodding, I guess I'm talking directly to you. There were additional ad hoc elements that were added, some of which are more protective, some of which are just confusing. I'm not going to cover all of them, but I'll highlight a few. All right, so starting on the primer, I'll go through this part relatively quickly. The European Union. It's important when you're looking at EU laws to understand that the EU is a supranational organization. It consists of its own institutions, it consists of its own laws. It also consists of member states that have their own laws and their own institutions, and overlapping human rights commitments as the backdrop to all of this. So I'll go through some of the relevant EU-level institutions for purposes of talking about the AI Act, a few necessary notes for those of you unfamiliar with EU law about what it is we're actually looking at, and highlight a few of the relevant member state level institutions at play here. So at the EU level, I'm not naming all of the institutions in the European Union, but just trying to grab the ones that are particularly relevant here. We've got the European Commission, which both starts legislation in the EU and behaves like an executive branch. We have the established in January 2024 AI office within the Commission that actually has monitoring and enforcement powers under the Act. We have the European standardization bodies, which are different from the tech standards groups we've been talking about both internationally and the US, in that they're more governmental in nature than the ones that we think about when we're in the United States. The institution I'm going to keep coming back to is the Court of Justice, which has an enormous role in the European data protection system and a large open question role here. Then additionally, and again this is more backdrop than within the Act itself, although the European Data Protection Supervisor plays a role in the Act, we have the entire apparatus that is European data protection law. This does not, the AI Act does not get rid of European data protection law. It preserves it and layers on top of it, and in one very small instance, actually amends it. Okay, so what did the European Commission do? Well, it serves this initial lawmaking role. It proposed the Act. It's responsible throughout the Act for any updates. If you're thinking about pacing problems and concerns about keeping up with technological and social changes, multiple parts of the Act may end up requiring amendment started by the European Commission. There are also many points in the Act where the Act grants the Commission a faster legislative process for updating portions of it, including, and here I'll go slowly, including the list of what constitute high-risk AI systems. Additionally, as I mentioned before, you've got the AI office in the Commission. It takes on a monitoring and enforcement role, especially for that after-the-fact general purpose AI system regulation. This I'll move through relatively quickly. The Act in a lot of places calls for technical standards. The European Commission has already requested harmonized standards, and the ETA, when I last looked at it, was April 2025. And European harmonized standards are different from what we see coming out of NIST and different from what we see coming out of, say, IEEE or ISO. They're more law-like increasingly. There's governance of inputs to them that make them look more, not agencies, but makes them look more agency-like. There's governance about the outputs. The Court of Justice has recognized that they become EU law and thus get treated as EU law. And then there is this sort of safe harbor-like operation in the Act itself that treats compliance with these harmonized standards as compliance with the Act. If an enforcer comes after the developer of an AI system and they can show that they follow these standards that don't yet exist, then they get a presumption of conformity against enforcement. And then finally, I said I'm going to keep coming back to the Court of Justice. Generally, the Court of Justice serves the role of interpreting EU law and interpreting the underlying human rights instrument in the EU, the Charter of Fundamental Rights. It takes on a huge role in data protection law, and here, very confusingly, it's kind of absent. So fundamental rights, if you recall, are one of the set of things that, set of risks that developers and deployers are supposed to mitigate before deploying and during deployment. They're all over the Act. They're fairly vague every time that they're referenced. And there's no individual judicial recourse for taking any violation of the Act before a court. Come back to that. All right, so if you're following along the outline at home, we've gotten through relevant EU-level institutions. Quick notes, again, this one will be quick, on EU law before we get to member state institutions. So this is one that should be fairly straightforward. EU laws are either softer or harder. They're either directives that require implementation or the regulations that take direct effect. A strange thing about the AI Act is that there was no AI directive before there was a regulation. If you look at data protection law, or you look at intermediary liability law in Europe, each of those had sort of a soft law, not fully harmonized run-through before they became more fully harmonized in regulation. The AI Act was a rush to hard law from the get-go. An additional note, if you're actually looking at those 458 pages, is that not all of the 458 pages are the same thing. The articles are binding law, again, with direct effect on member states. The recitals are something more equivalent to guidance or legislative history. However, when courts interpret EU law, they use a purposive interpretation and they'll refer to what's in the recitals, which functionally makes them harder and more like hard law. Okay, now, last very big overview about the European Union. You can't read the AI Act in isolation. It's constrained by, it refers to, it overlaps with a lot of other existing EU level law. I spent a long time trying to get my head around the General Data Protection Regulation, and that felt almost doable. When I tried to get my head around the AI Act, it exploded. Because all of these different things are at play here, and there's not really a clear map through line of how they interact. We've got the Charter of Fundamental Rights, which is a backstop. However, we don't have a court enforcing it, at least not through this law. We have the General Data Protection Regulation still existing, and some overlapping requirements in the AI Act that effectively reference the GDPR. We have the Digital Services Act about online intermediaries, and so anytime you see something I discuss about general purpose AI, you'll see that that's still applying there as well. And then the Copyright in the Digital Single Market Directive, which has a whole regime for training data that's referenced in the Act. And then the biggest one is product safety laws, which were new to me. There is a 2023 updated General Product Safety Regulation in the EU, and then what's referred to as the new legislative framework, which is a combination of regulations and directives about very specific objects, including medical devices, toys, elevators, etc. There was also another law in play that now, by all accounts, is dead. The AI Liability Directive, if you look at the AI Act as being product safety based, the liability directive would have been the tort element of that, as opposed to the regulatory element of that. And now that's not happening at an EU level, which means it's happening at a member state level. So that brings us to relevant member state level institutions and laws. I'll remind you that member states in the EU have their own laws and their own institutions. So this regulation will take direct effect on them, but it's going to interact, for example, with how they interpret tort liability. The other institutions that you should be aware of are these bodies responsible for fundamental rights protection. Member states have to designate which bodies they perceive, which domestic bodies they perceive to be falling in that category under the Act. Notifying authorities, we'll come back to those. Market surveillance authorities, we'll come back to those. And I'll note that existing data protection authorities may end up serving the market surveillance authority role. Okay, so now we're at the actual Act itself. So the contours of the AI Act are fairly easy to simplify, maybe oversimplify, and fairly well known. The main contours involve the risk tiers. Then you have, as I said, this after-the-fact addition of general purpose AI systems, and then these ad hoc elements that I'll come to at the end if I have time. For the infamous risk tiers, we have arguments about whether there are 3 or 4 or more or fewer. I tend to understand them as 3 tiers. There's the tier of unacceptably risky AI systems, high-risk AI systems, and then everything else. But don't be confused by these, because if you're a general purpose AI system, you've got your own set of responsibilities going on. Unacceptably risky AI systems are banned. They're defined in Article 5 of the Act, and that set of bans, we talked about how the Act may or may not get updated, is likely not to get updated because to update it requires going through the usual EU legislative process. Just pausing for a moment, I think that to a US audience, this aspect of the Act gets underemphasized. The idea that you would ban anything technological at all is a big swing in tech policy. And while there has been a lot of EU-side criticism of watering down some of the bans, making them too narrow, et cetera, especially the parts about facial recognition, it's still a big deal from a US perspective to have those on the books, and I think will be useful for US policymaking to normatively be able to refer to the things that fell into this category. Examples include the use of AI for social scoring, the use of AI for predicting the risk of committing a criminal offense, the use of real-time biometric systems in public places for law enforcement use, and the use of AI to infer emotions in very specific contexts at work and at education. All of those things are banned. Now you'll notice if you're a lawyer or close reader that the biometric ban in particular has got a lot of caveats. Right? Use of non-real-time biometric systems, not banned. Use of biometric systems in private spaces, not banned. And use of biometric systems for non-law enforcement use, not banned. Right? But again, I think normatively, it's a big deal to have these as the outer markers of unacceptable behavior. Last note on these is that you'll notice how much this is influenced by US-based news. So a lot of the bans, I think, can be drawn back to news stories about particularly egregious uses of AI in the United States. One I didn't put up there is what I refer to as the Clearview ban, which is basically the ban on publicly collecting facial imagery from the public internet in order to produce a facial recognition software. Okay, this is the core of the Act, the high-risk AI systems that are regulated. They're defined in Article 6 of the Act and in Annex 3 of 13. And they're updated by the Commission through an easier process, delegated acts, as indicated in Article 7. The Act itself gives the Commission guidelines for when a system, or like criteria for when a system can get added to Annex 3 as be designated high risk. And additionally, at least in my reading of it, it's relatively hard for the Commission to take things off of Annex 3 once they're on there. Lower risk AI systems, this is the only time I'll really cover them in this slide unless they're general purpose AI, are basically under voluntary self-regulation. So they can follow codes of conduct. They can follow the regulation for high risk systems. If they're worried in particular about ending up on the list of high risk AI systems, you might think about corporate compliance officers pushing towards voluntary compliance to avoid that. And even though they're not regulated under the AI Act, they may nonetheless be bound by other laws, certainly by the GDPR, and are regulated by member states and can be regulated by other parts of the Act. Okay, so here is how high-risk AI regulation works. It's this process that's transplanted from the new legislative framework, and what it does is it frames AI systems as a product. They undergo conformity assessment, we'll talk about what that is shortly, and then they label the product, including using digital labels, as CE, and after that, they can circulate it on the internal market in the EU. And then that assessed and labeled product, is subject to both registration and post-market supervision. If you think about this in terms of product safety, it kind of makes sense, right? Making this up, you have a toy, they check the toy and make sure everything is a-okay, they put a label on it, third-party standards organization type place says, yep, good to go. They circulate it in the internal market unless and until something goes totally wrong and they recall it. That's the way it works. However, AI systems are not products. So I want to place this process or transplantation against the backdrop of the purpose of the Act. From a US perspective, we often think of the European Union as being awfully focused on rights, on being much more precautionary than the United States. And the AI Act, I think at least initially, has really been framed this way in US conversations. And here we see on the purposes of the Act, this emphasis on a high level of protection of health, safety, and fundamental rights, and a requirement that the harmful effects of AI systems be prevented. But if you look at the other part of the purpose, we see a trade-oriented, innovation-focused purpose behind the Act. And this, I think, drives the EUI Act much more than US audiences often give credence to. So the EU is as much an internal market as it is a human rights enforcing set of institutions. And this product safety approach allows for a shortcut to allowing that internal market to function. Okay, so back to the actual substance of the Act. High-risk systems have to mitigate risks to health, safety, and fundamental rights. These obligations fall largely on providers of AI systems. Providers of AI systems are really what we would think of as developers of AI systems. But all of this risk tier and risk mitigation relies on a particular mental model of AI, so I'm calling back to the presentation from the very beginning of today. It presumes that we're talking about a system where a developer developed that system for a particular purpose, and the deployer then uses that system following instructions for a particular purpose. That's not general purpose AI. The very notion of general purpose means there is no specific purpose, either during development or during deployment. So we can see again illustrations, concrete illustrations of this in Annex 3, which is the list of high-risk AI. We see that the use of AI in education is designated high risk, the use of AI in employment is designated high risk, the use of AI for access to essential public and private services, the use of AI by law enforcement. Remember, law enforcement use of biometric systems in real time in public spaces is banned. Everything else is high risk. And then judicial use of AI. Those are all considered high risk. And if we think to the sort of paradigmatic case of, say, the COMPASS risk assessment system, the idea behind these classifications is that developers created these systems using data from specific contexts to deploy them again within specific contexts for specific uses. I promise you I won't go through this in detail. So what if you are an AI provider under the AI Act, and you are a provider of a high-risk AI system, there is actually a lot of law in there. And again, as an American looking at this, I think there's more there than sometimes EU policy wonks give credit to. So there's a risk mitigation system that you have to create. It's largely process-oriented, but not entirely. There's some substantive requirements in it. There are specific rules in Article 10 about data and data governance. For those concerned about the bias in, bias out problem with data, there's some very specific provisions trying to deal with that, including requiring testing, including requiring a fit of data to purpose, including requiring statistical validation, which again, if you followed COMPASS, is not the case in the United States. There's a technical documentation section, Article 11, that requires the creation and keeping of records. There's an automated logging requirement that requires the logging of incidents and an obligation to retain logs. There's transparency. For me, I got very excited, but it's not transparency to users, it's transparency to deployers. So not to individuals affected by AI, but to those who deploy the system once they've received it from the developer. Article 14, pretty fascinating if you're interested in humans in the loop, talks about designing for and enabling human oversight. There's no actual requirement that you have human oversight, but if you are a deployer, you have to implement whatever the provider told you to do as part of the risk mitigation system. And then finally, we've got substantive-ish requirements in Article 15 about accuracy, which is a big deal, robustness, and cybersecurity. So thinking at least a little bit about planning for systems to fail and planning against adverse attacks. Now to the enforcement. And again, these slides were supposed to have animations step by step, so bear with me. I think it's helpful to understand that the Act has relevant elements, as do a lot of EU laws, of collaborative governance, co-regulation, etc. So when I talk about governance and enforcement, some of that is supposed to happen internal to companies. Some of it is supposed to be a link between a company's self-enforcement and an external regulator. And some of it is hard law hammers for the external regulators to come and try to force the self-regulation. So this first list of internal enforcement is really about systems set up, corporate governance systems set up within an AI provider. It includes a quality assurance system, documentation keeping, and conducting the conformity assessment process, which can actually be internal or external. We'll get to that. Then this sort of link between internal and external enforcement. An AI developer or provider has a duty to correct for risks and to disable or withdraw or recall the system itself if they find that there are risks that happen during deployment. They have a duty to report certain levels of problems to market surveillance authorities, and then they have a duty to respond to requests from authorities if those are reasoned requests. And then again, some versions of the conformity assessment process, which we're about to get to, do use external parties. Okay. Skipping this, but there are also obligations for deployers, for importers, and distributors. Ask me more in the Q&A. All right, so just to come back to the bigger picture again. The bulk of the Act is about these risk tiers. Within the risk tiers, the high-risk systems get the most attention. They adopt the process for it from the new legislative framework to treating AI systems as a product, and they undergo a conformity assessment saying, I conform with the requirements of the Act, label the product, put it on the market. The process for conformity assessment is outlined in Articles 43 and 47. And providers of AI systems, high-risk AI systems, are going to do one of two things, depending on where they fall in those articles. They either conduct a self-assessment, where they say, oh, yep, we're doing our risk mitigation, we've done our data governance, we've done our, I can't think of anything else, all the other things we have on the other slide. Or, as is more typical for product safety, there's a third body party, not government, but basically certified by the government, that can come in and do that assessment for them. However, most of the NX3 high-risk systems are going to involve self-assessments, not third-party notified body assessments. That's particularly fascinating to me when we go back to this, is the AI Act really about fundamental rights, or is it about ensuring lowering of barriers to the internal market? Because if you're a safety-critical AI system, or a component of a safety-critical system, you have third parties that are going to oversee this conformity assessment process. If you're merely harming fundamental rights, you just self-assess. All right, now to the enforcement institutions. The two types of institutions member states are in the process of designating, hasn't happened yet, include the notifying authority, which oversees those third bodies, and the market surveillance authorities, which are where the real meat is. Those are on a member state level responsible for monitoring, enforcing, and inspecting AI systems. The national powers and authorities protecting fundamental rights can't enforce, but they can also make information requests. At an EU level, the enforcement institutions include, recall back, the European Data Protection Supervisor. So if we're talking high-risk systems in European Union institutions, the EDPS functions as the inspector and enforcer. And then if we're talking general purpose AI systems, those are subject to enforcement by the AI office. Everybody okay? Okay. So what does a market surveillance authority actually do? Think about them as being the entity that steps in at the stage of post-market monitoring and enforcement. If they have sufficient reason to suspect that a particular AI system presents a risk, then they evaluate whether it in fact is in compliance with the Act. If they find non-compliance, then they correct it, or they direct the AI provider to correct it. That can include recalls or withdrawals, which can be potentially contested by other market surveillance authorities or the Commission. But the real heft in the Act, and again, there's questions of whether we'll ever get to it, has to do with the fines. So as with the General Data Protection Regulation, which had pretty exorbitant fines that, by all accounts, scared a lot of companies worldwide into compliance, the AI Act also on paper has really significant fines. If you're the provider of an AI system and it's a banned AI system and you deploy it in the EU, you face an administrative fine of up to 35 million euros or 7% of your worldwide revenue. That's 7% of your worldwide revenue, whichever is higher. If you're a high-risk AI system provider or deployer or importer, you face up to a much smaller fine of 15 million euros or 3% of worldwide revenue. And then we have fines backing the whole information exchange that's supposed to occur during the notified body process, and those entail 7.5 million euros up to 1% of worldwide revenue. For general purpose AI, it's the same as high risk AI. And then I found this particularly interesting. If the union's institutions are in violation of the act, the fines are really small. So, I told you I would keep coming back to this. The largest puzzle in how this is all going to fit together is what is going to be the place of the Court of Justice. I wish I could, in a nutshell, describe what various amazing PhDs were trying to explain to me while I was reading and rereading this thing back last year. So, again, with respect to the General Data Protection Regulation, I and others have made the argument that a lot of the self-regulation or co-regulation works more than you think it should, because there's this fear that you have this really data protection focused human rights court that's going to come in and find companies to be in violation of the law. Here, we don't have that. The only explicit role for the Court of Justice is that it can review decisions to fix fines. That's the only time that it appears in the law. There is no individual right of action. There's only a right for individuals to lodge a complaint with market surveillance authorities, which sounds about as bureaucratic as it actually is. Now, as I've also had explained to me, this doesn't prevent individual rights of action. So, you could potentially invoke your data protection rights and get to an individual claim under the GDPR. You could invoke your rights under anti-discrimination law and invoke your rights under another law. But what it doesn't do is allow for individual enforcement of any of the risk-based governance of fundamental rights violations in the Act. Okay, general purpose AI systems. Again, this would have been more effective with my original animation, but in which tier are general purpose AI models? None. They're not there. That's a little bit of an untruth in that general purpose AI models can turn into high-risk AI models if they are then used in those specific situations for those specific purposes. Then the deployer shoulders all the compliance burdens. Okay, but in general, general purpose AI models are just treated differently. They fall into two categories: general purpose AI models without systemic risks, and general purpose AI models with systemic risks. If you are a general purpose AI system or model without systemic risks, and I'll get to what the definition is shortly, then largely your requirements are documentation requirements and disclosure requirements. Open source models, not subject to these. Then we see, I had warned you about some of these weird references to and overlaps with other EU law, 3 copyright-related requirements for general purpose AI. You have to establish a copyright policy, operationalize a different law's requirement that allows rights holders to opt out from training data sets, and this one my students really loved for purposes of thinking about copyright lawsuits in the United States. You have to drop and make publicly available a sufficiently detailed summary of the content used for training your model. If you're in the US, you get excited about that. If you want to sue for a copyright violation, because now you know that your content is in the training data set. General purpose AI systems with systemic risks. Those systemic risks are defined in Article 51 and Annex 13. Those include primarily things about the size of compute, but there are other proxies in the annex for scope of impact. So largely when we talk about systemic risks, we're talking about model size. Right? We're not talking about necessarily specific deployment areas or specific levels of impact. And then that last bit is that there's an Article 52 procedure where a scientific panel can also spur the commission to designate certain general purpose AI models as models with systemic risks. They have more compliance obligations, and they're not insignificant. So one, they have to do everything that a general purpose AI model has to do anyway, including that copyright stuff. And they have to perform a model evaluation, conduct and document adversarial training, assess and mitigate possible systemic risks, report and document information about serious incidents, and attend to cybersecurity protection. So to Colleen's presentation earlier about the Biden executive order, there's quite a lot of overlap between the content of that order and this content of regulation. Again, I mentioned open source exceptions. So if it's an open source model, then you don't need to document it or downstream disclose to future deployers. The logic behind this, I guess, is it's open source, and so transparency is less of a problem. You do, however, still have to comply with the copyright requirements, and if it's a model that presents systemic risks, you still have to comply with all that risk mitigation. How that works in practice, I have no idea. Last part of the contours. So then there's the other, and this really requires just like spending a good long time with the act looking for things you care about. If we look at the general transparency obligations, for example, we see echoes of some things that have come up in US state laws. So for example, speaking to the previous presentation, Article 50 requires the watermarking of synthetic content. It also requires transparency to individuals that they're interacting with AI systems if it wouldn't be obvious to them under certain circumstances. There is a fundamental rights impact assessment requirement that falls on AI deployers, not providers. So if they're using certain AI, high-risk AI systems in certain contexts, they have to conduct yet another impact assessment of how it would impact fundamental rights. That has echoes with and potential overlap with the data protection impact assessments of the GDPR. And then finally, this one I'm spending some more deep time with right now for a book chapter, but there is a right to explanation of certain AI decisions in the AI Act. If you harken back to the General Data Protection Regulation, there was a very vociferous debate, including from yours truly, about whether it contained a right to an explanation of a significant AI decision. The GDPR itself doesn't have that language in there, but there's many reasons to think that there is a requirement. However, the AI Act, the less fundamental rights protective of the two, explicitly has a right to explanation. So one thing I like to point to is that if you were a pessimist about GDPR's right to explanation, then this actually does something. If you were an optimist about GDPR's right to explanation, this probably does a lot less. So finally, oh my gosh, I'm gonna get to the end right on time. So finally we get to some policy observations. And I put these into 3 buckets just to reflect the risk tiers. So one is just an observation about the legal construction of AI in this act. The second is returning to this theme of what are we doing regulating risks as opposed to providing rights. And the third, I've been using this term legal exoskeleton, which I think is going to show up published somewhere at some point by me, which is to say, like, when we talk about hard law and soft law, we usually think about something as hard or soft law. The AI Act, and in fact the Colorado AI Act to some extent too, are really hard law outsides with soft and mushy standard insides, right? What the technical standards say is really going to matter, and that hard law exterior apparatus may or may not matter depending on what ends up in the technical standards. All right, so first, this question of like, what is going on here? I've referenced this throughout the presentation. But if we ask these questions of what exactly does the AI Act think it's regulating, towards what end, using what institutions, it's pretty obvious that the whole system is a legal transplant from product safety regulation, and that it treats problems as product safety problems, even where they are hugely different in type and in application in other contexts. In terms of values, as I noted, health and safety are prioritized, which is fair, but fundamental rights are referenced throughout the Act without having a fundamental rights institutional apparatus to back it. In terms of institutions, again, these are the institutions of product safety regulation. So we have technical standard setting organizations, market surveillance authorities, the mysteriously absent Court of Justice. And this means that when we're talking about regulating risks to fundamental rights, Weirdly, we can get into a conversation in the Q&A if you want to about this, but weirdly we're talking about fundamental rights on a group level with ex-ante regulation, not what we typically think of as human rights, which are individual rights with recourse at an individual level ex post. And you can see this even from the beginning framing, the second definition. First definition in the Act is of AI. It's the OECD definition, basically. Second definition in the Act is, what is risk? Risk is a mathematical calculation, right? It's a combination of the probability of an occurrence of harm and the severity of that harm, or an actuarial calculation. And we've had this conversation in privacy for years, decades, what feels like centuries. How do you quantify harm to fundamental rights, right? And how do you do so when you're talking not about an individual, but about groups of individuals and communities of individuals? And even moving away from that quantification problem, the lack of individual remedies is extremely an extreme departure from how we treat human rights in other circumstances. So finally, closing with this legal exoskeleton concept, and again, others have written about this quite a bit. The enforcement mechanism of the Act, which involves market surveillance authorities going and trying to decide when a company or an AI provider self-certifies as being in conformance with the Act, they are supposed to look to whether that provider has followed a set of harmonized standards. The harmonized standards come from the European standards organizations. And I did find this wrinkle, which at least is somewhat reassuring, which is that the Market Surveillance Authority can still find non-compliance with the Act if they find the harmonized standards to have shortcomings in them. But this is a significant uphill battle, and I think relatively unlikely to occur. So the oddity of these technical standards is that if you have an instrument focused on fundamental rights and you're outsourcing what is adequate risk mitigation to a technical standard setting organization, you're asking technical standard setting organizations that aren't accountable to the general public in the same way to assess what is an adequate level of risk and what's an okay level of harm. Last bit is that very last point on this. Technical standard setting organizations are also required by international trade law not to create trade barriers in the form of technical standard setting organizations. That was a highly technocratic way of saying European standards organizations have really good reasons to try to harmonize to international standards and US set standards. One of the most interesting things I've encountered in looking at the kind of transatlantic dynamics of this is that NIST very straightforwardly wants to be pushing US standards as the international standards, or at least transnational standards. That's a very explicit goal as part of going back to Colleen's presentation, this shift to looking at AI as industrial policy, which is not fully a shift at all, in my view. So if Europe is trying to get out of the gate and create some sort of, my least favorite term, Brussels effect, by creating an act that's going to lead everybody into compliance with EU law, it's a very strange move to have the core fundamental rights instruments in the act be technical standards that have to harmonize to international standards and US law. Thank you. Now we have time for Q&A. Yes.
I have two questions. One is, does the EU AI Act apply to EU providers and implementers if such AI system is implemented outside of the EU, as long as a provider or implementer is an EU company?
That's a great question. I think that my memory of the extraterritorial stuff is that if it's an EU company, it applies to them while they're in the EU. I don't know what happens if you're an EU company, you built it up in conformity to the AI Act, and then you sent it elsewhere. Now can you move away from it? Yeah.
Right. And then the second question is, I know you mentioned, those limitations were only in the US, the law enforcement gets around Fourth Amendment by procuring those things from private entities.
Yeah.
Can law enforcement in EU get around it the same way as the US does?
So, thank you. So my understanding of the answer to that question is that Big Brother's little helper's problem is not a loophole out of that ban. However, multiple people have pointed out that the ban is so specific and that you are functionally creating the infrastructure to allow law enforcement to do it as close to real time as possible, such that the ban doesn't have a whole lot of meaning in practice. So it's less can they get around it by asking private entities, and more can they ask 45 seconds after it's been in real time. Yes.
Thank you for the presentation. That was incredible. I have a question that's a bit convoluted in my head, so I hope you can make sense of this. I feel like one of the challenges with technical evaluation of these systems, we don't often know what sort of harms we're looking for. And while the risk framework seems to be nicely, segmenting out the high risk and lower risk things, are there specific types of harms that people are concerned about with general purpose models beyond the harms that are outlined in the high risk and absolutely not okay sections?
So this again goes to the what are these fundamental rights that are being referred to throughout? They at one point in the Act it refers specifically to the EU Charter. The EU Charter contains many fundamental rights. Those include things like not just harms to everybody, or at least I often think about the EU with respect to data protection. We're talking harms to freedom of expression. We're talking harms, anti-discrimination harms. We're talking, harms to employment, etc. Very long list. And so, what that's going to mean in practice is largely probably going to come out of these, probably going to be highly procedural. If NIST is any good example for this, standards that are still not going to really tell you what is the harm you're trying to prevent. It's just going to give you a lot of process for how to go about internal to your company evaluating it.
Because it's not quantifiable. Yes.
Yeah, and not quantifiable.
Yeah.
And socio-technical system, again, to reference the previous. Yeah.
Just as a quick follow-up to that, how are we supposed to compute the probabilities of these harms if we can't? Okay, it was sort of a rhetorical question,
Yeah.
but okay.
Yeah, so I'll go up a level and say, I think there's a place for ex-ante risk mitigation. I really do. I also think that it doesn't work in the human rights context unless it's also coupled with the individual rights aspect of the law. Yes, sir.
So over the last couple of days, right from Paris to the last couple of hours, so over the last couple of days from Paris to the last couple of hours, big tech has opposed the EU AI Code of Practice, and most new AI features that are available to the entire world are being exempt from EU launches because of heavy regulations. How do you think this is going to pan out? Is the EU AI Act placing a lot of burden on big tech?
No. I think a lot of this is performative on the part of companies. And disclosure, I sat on the AI task force in Colorado that was formed in response to our governor's professed skepticism about the Colorado AI Act, and this came up over and over again too. Right? The anti-law, anti-regulation rhetoric of companies is to come in and say, you're going to make this so burdensome that I can't do anything, and therefore I'm going to depart your jurisdiction. And one of the responses to that is to say, well, first of all, if you actually look at this law, it's long, but it's not burdensome. If you get to a point where the standards come out and this becomes really just a compliance checklist, then the core aspects of the law that might do anything are going to be things like requiring accuracy, or are going to be things like check to see that your data set actually is complete and is relevant to the problem that you're trying to solve. So I don't see it as being, again, I'm not in a company and not a small business, but I don't see many of these laws as being particularly burdensome, and many of exemptions or exceptions. The other thing I would say is that companies get what they ask for, and they most certainly are asking for lighter touch regulation or co-regulation. And then when they get the co-regulation, they then turn around and say, oh no, this is really too much for us. Christopher.
So, Margot, thank you for what is the best presentation on the EU Act I've been to. So it's been really helpful. I want to draw you out on a couple threads you keep dropping. One is you seem to be critical of this idea of the shift. You're implicitly critical about the shift to a products liability frame, without actually
not products liability, product safety.
Product safety.
Yeah.
I want to draw you out more on that. And the other thing that it's interesting that Sam and Kat are getting at, which is you seem to think about this tension between rights and risk framework. And so the natural reaction I had is, for complex systems, there's emergent phenomena you only find out at the end. And by looking solely at the inputs, we're missing something really important. And I always thought this was, in some ways, a positive development. But I get a win from you that you're feeling that some reservations about that shift, that there's something complete. I'd love to hear more of your thoughts about that as well.
Yeah, so there are lots of good reasons why we want to look at either data processing systems or AI systems, more specifically from an ex-ante perspective, trying to change things before they end up getting deployed on the public. There's the issue of scale. It's better to fix the system than to try to clean up ex-post harms after the fact. There's the issue of regulating through design, which you regulate through design by building a system a particular way, not by trying to, in some cases, impossibly figure out how to change the system after the fact. So all those reasons counsel for some kind of ex-ante systemic level approach, which is again why I'm not anti-risk regulation, period. But the issue is if risk regulation comes in and replaces any real form of ex-post relief or compensation, then a couple of things happen. And Alicia Solomon-Biederman has written about this too. You end up lacking the feedback mechanism that individual rights of action can provide for an ex-ante risk regulation system. So you don't get to find out what is a big enough harm to constitute a harm. You don't get to find out, what does it mean to have algorithmic discrimination as opposed to just employment discrimination? Because you never get the court in there, or courts in there, doing that definitional work, and you then don't have that feed into the risk mitigation process. Also huge risks of capture if you don't have the check of individual rights or liability on the other side. But that's it in sort of a nutshell. Yes?
Well, in the last 2 weeks, the AI summit in Paris, France seems to pitch itself as to boost the investment in AI industry. So, do you think that EU's emphasis on innovation may kind of conflict with this EU Act, or what's your idea between the dynamics of the innovation and the strict regulation?
It's absolutely part of the investment in innovation. So it's supposed to be EU innovation, registered trademark, right? It's supposed to be the version of AI that comes out of all of this is supposed to be AI with EU values baked into it. Color me somewhat skeptical if you haven't gathered this already, because I don't know that this particular regulation will achieve that. There are other laws in the EU that I think will go further towards that end. And then in terms of the barriers to investment or to growth of AI systems within the EU, Anu Bradford has a piece on this that I largely agree with, which is that there are many other reasons why the EU isn't producing these technologies that aren't traceable to having this regulation in place. Yes?
Hi, thank you so much for this great talk. I was hoping you could expand a little bit about what you said about the European standards body. I think you're referring to Senelec. Is it okay? So I'm part of this working group on the code of practice on general purpose AI, along with 900 and something other people.
Bless you.
Yeah, thank you. And one of the criticisms in the different civil society circles that I'm part of that are also participating in this working group is that we're going to do all this work, we're going to get this code of practice, and then Sensenelec is going to butcher it and turn it into something horrible. But I've actually been asked, well, there's a guy who works at Sensenelec, or with Sensenelec, Sebastian Hollandsleben, who I saw speak in Paris a couple weeks ago, and his take was that Sensenelec is a great place to talk about human rights and socio-technical problems, and he's like very rosy about the potential for it. So could you explain a little more, like, what is the mechanism by which Sensenelec could be forced to weaken this, and are you also worried about that? And anything you can say about the working group and the relationship between the two would be great.
So I'm gonna acknowledge limits to my expertise and say the specific procedures by which European standard setting organizations operate are beyond my current scope of knowledge. However, I know people you can talk to. What I'd say is, again, going back to early days of internet regulation, there's been longstanding conversations in digital policy circles about accountability of standard setting organizations, and the extent to which they make what are really policy decisions in what look like simply technical decisions. This is actually not even that. So Brian Choi, who I have the pleasure of calling a colleague as of next year, has written a great piece on what he calls NISTs on standards, and talks about how in the United States context we have something that's purportedly a technical standard setting organization that just issues increasingly policy documents that are not really technical in nature at all. And so that begs the question for me and for others of, if what you're doing is policy making, it's not, measuring the size of the plug and the outlet, like, why is this happening in those particular institutions that have a long history for all that they're trying to, after the fact, add in civil society participation, have a long history of being primarily accountable to tech organizations, or really tech companies and technologists within tech companies. Yeah, Judy.
Know where the microphone is, so I'll just talk really loudly.
No,
I'll repeat the question, I promise.
I mean, the alternative is the way in which the U.S. traditionally does
this, which is through RegDeg, which basically leaves it to industry standard setting bodies. So like, at least NIST and the AI Safety Institute and the things that are stood up in Europe include broad public participation and actually is centering the public values in those technocratic processes. So what are you proposing? You like the other system better?
I do not. What I'd say is that I think there's just a question of whether we should be using technical standards setting at all for some of this. I didn't like, if we go back to work I did ages ago about regulation of unmanned aerial vehicles, I don't love what US agencies did around that either, right? I like laws that have boundaries that tell people what to do. Now, the difficulty is when you have a developing technology, there's always going to be some significant space around what it is you tell companies to do or not to do, because you don't know exactly where the technology is going. But to some extent, I think that the metastasizing of the AI Act into a 458-page document is just like vagueness upon vagueness upon vagueness delegated to another institution to hide how you're going to define what the vagueness means.
I have a question about derivative products from, say, general purpose systems. For example, one can harness a limited number of capabilities from a general purpose models, or also restrict the application domains to produce these derivative products. How are they regulated in your three-tier?
Assuming I'm understanding the question correctly, and it might not be, so if you take a general purpose AI system and then you apply it into a specific context that is listed in Annex 3 as a high purpose AI system use, you are now considered to be an AI provider that is regulated under the Act. And that, I don't know what that's going to do. I think it may limit the use in the EU of general purpose AI systems for these specific purposes, because I'm not sure how you can end up complying with the AI provider requirements when you are just adapting a generative AI model for specific use.
Okay, thank you.
I have two questions from online, and then I'll come back. Okay, so one question was, you said there's fines for incorrect or misleading info to notifying bodies. How do you identify that? My answer is brief, I don't know. I don't know how you would manage to find out that incorrect info or misleading info was given to a notifying body. There's multiple imagined layers of oversight and self-reporting, but it depends on how good or bad an actor is for that to work. And then a second question was, does any agency of the EU verify if AI results are accurate? I guess the answer in short would be no. The complicated answer would be maybe, because if you have an AI provider that declares it's in conformity with the Act, because it says that its results meet the accuracy requirement, and then a market surveillance authority says, nope, you actually didn't produce accurate results, the market surveillance authority can then fine them for not actually being in compliance with the Act. Okay, last question.
Did you mention there is exemptions for small businesses?
Yeah, so I did not pull all of that together for this presentation. I can follow up with you. But there are various places where SMEs occur throughout the Act. So in thinking about fines, for example, the amount of fines that can be levied on a small business are less.
The reason I ask that is because I know in Europe there are much more stronger employee rights than we have in the US. So in the US, for example, SBA counts employees toward headcount. It doesn't count independent contractors. So you can get around all of that by just hiring a bunch of independent contractors. So is that the same in EU as well?
I would have to check what the definition of SME is in the Act to be able to answer that.
Thank you.
Thank you. Thank you all so much for having me.
So thanks very much for coming. I hope you feel like all tutored. And the whole point of this was so that our speakers tomorrow can really hit the ground running and talk about things at a high level. So now we have the background, and tomorrow I look forward to seeing you. And have a good evening and good day tomorrow. So thanks again to our speakers.